Listen, sweetie, buckle in for this one, because the whole timeline is about to catch fire, and I promise you, by the time we're done here tonight, you are going to be looking at this David situation with brand new eyes. Yes, that David. The one whose name has been sitting at the top of every entertainment feed, every legal blog, every whisper thread on the internet for months now. And let me tell you the reason. A judge, a real, sitting, robed-up judge, just did something almost nobody in the industry saw coming. He signed off on releasing a stack of grand jury transcripts that were supposed to stay buried forever. Sealed. Confidential. Untouchable. And now, David's defense team is about to open that file and find out exactly how prosecutors have been building this monster of a case behind closed doors for months. Baby, this is not a small development. This is a room-shaking, brand-changing, career-altering shift in a case that has already had the whole industry holding its breath. So sit tight, because we are peeling this thing back layer by layer, and by the time the credits roll on this one, you are going to walk away with information you will not hear anywhere else on this platform tonight. Now, in case anybody forgot how we got here, for months, this entire David investigation has been running like a ghost ship. Prosecutors were meeting, witnesses were talking, forensic teams were working, and almost none of it, I mean almost zero, was leaking out into public view. Everything happened in the dark. Everything happened in the quiet. And that is by design, because grand jury proceedings in both Texas and California are locked up tight, and the rules around them are strict for a reason. But every so often, a judge decides that the balance has shifted. That the defendant's right to know what's being said about him behind closed doors outweighs the tradition of secrecy. And that is exactly the door that just got kicked wide open in David's case. The whisper going around the courthouse is that these transcripts could turn out to be one of the single most valuable pieces of paper his lawyers ever get their hands on. And once you understand exactly why, sweetie, the entire shape of this case starts to look very, very different. Anyhow, here's where it starts getting really juicy. Because when you look at the timeline of the grand jury sessions, and this is public now, folks close to the situation confirmed it, you realize prosecutors were not just running a quick presentation and calling it a day. Oh no. What they were running was a full-on investigative operation. Multiple grand juries. 3 separate panels. 18 days of sworn testimony. Dates stretching all the way from November of 2025 straight through February of 2026. That is not a case that got built overnight. That is a case that got built brick by brick, witness by witness, receipt by receipt, over a period of months while the rest of us were still trying to figure out what was even happening. And now David's team gets to see the blueprint. The whole architecture. The rooms, the halls, and the load-bearing walls of what prosecutors have been quietly assembling this entire time. So look, why does that matter so much? Let me walk you through it. When a prosecutor puts a witness in front of a grand jury and that witness swears an oath and gives testimony, that testimony becomes a permanent, locked-in version of their story. Fixed. Documented. On the record. If that same witness later shows up at the preliminary hearing, or later at a full trial, and they suddenly remember things a little differently, or they shift a date, or they soften a detail, or they add something that was never there before, the defense can now pull the paper trail and put it right in front of the jury. That is what lawyers call impeachment, and that is why criminal defense attorneys treat grand jury transcripts the way a jeweler treats diamonds. Sweetie, this is gold standard cross-examination ammunition, and Blair Berk, David's lead attorney, the woman who is currently running his defense with a scalpel, just got handed a mountain of it. And you can bank on it, she is not going to let a single page go to waste. And don't sleep on the fact that Blair Berk is not some rookie. This woman has been doing this at the highest level for years. She is known for methodical, forensic, ice-cold cross-examination. She does not miss. She does not fumble. She notices things other lawyers walk right past. And now she is about to sit down with a comprehensive record of how prosecutors framed every single question, what evidence they emphasized on what date, which witnesses got hammered on which topic, and how the story they are trying to tell in open court compares to the story they were quietly assembling in secret. You can bank on it, every syllable of those transcripts is going to be pulled apart, tagged, cross-indexed, and weaponized. That is not speculation. That is what elite defense teams do with this kind of discovery. That is the trade. That is the craft. Now, before I take you deeper into what those transcripts might actually contain, we have to zoom out for a second and remind ourselves what this case is even about, because a lot of people have been following the headlines without ever really understanding the core of it. David Anthony Burke has entered a plea of not guilty to multiple serious criminal charges tied to the case involving Celeste Rivas Hernandez. Prosecutors say the central events began on April 23, 2025. Now, those allegations, I want to be crystal clear here, because this is the fair way to talk about a case that has not been decided. Those allegations have not been proven in court. David is presumed innocent until the evidence establishes otherwise through the formal process. That is how the system works, and that is the framing we are going to hold to. But what we can talk about, freely and legitimately, is what the record shows about how prosecutors have been operating. And baby, the record is loud. The whisper going around is that one particular date on the grand jury calendar has legal analysts absolutely fixated. Around December 9, 2025, the Los Angeles County Medical Examiner reportedly wrapped up the examination of Celeste's remains. Now, the official report on that examination didn't drop publicly until April of 2026, but the timing? The timing is doing all the talking. Because that examination was landing right in the middle of the grand jury sessions. Folks close to the situation swear that the medical examiner's forensic conclusions were the exact material prosecutors were building their evidentiary spine around during that stretch. That report ultimately classified the cause of Celeste's passing as multiple penetrating injuries, and the manner as homicide. Those are not soft words. Those are the two words a prosecution builds an entire case around. And when you overlay that report on top of the grand jury calendar, sweetie, the picture gets very, very clear. Anyhow, February of 2026 brought its own bombshell, and this is the part where things get really strange, so pay close attention. Court records show that a witness identified as Neil Langston, publicly known as Neo, connected to David through his close personal and professional circle, walked into the grand jury room and testified for something like 30 to 40 minutes. Just that. 30 to 40 minutes. Now, on the surface, that might sound routine. But if you understand how these proceedings run, you know that a session that short is almost never routine. Long grand jury appearances typically mean prosecutors are running a witness through a full narrative. Short appearances usually mean one of three things is happening in that room, and each one of them is loaded. And once you know the three possibilities, you cannot unknow them. Option 1, the witness got in there, took the fifth, invoked their constitutional right against self-incrimination, and the session basically ended before it started. Option 2, the witness was there to plant a small, specific, foundational fact, a name, a date, a location, and prosecutors didn't need anything more from them. Or option 3, and this is the one people are really whispering about, some form of immunity arrangement was quietly on the table. Now, which of those actually applied to Neo's appearance? Publicly, nobody knows. What we do know is this: investigators considered his testimony important enough to subpoena him for further appearances, and when he failed to show, they went out and arrested him on a failure to appear warrant all the way up in Montana. He has since been extradited back to Los Angeles, and the expectation is that his testimony is going to become a much bigger piece of this puzzle in the phases still to come. That is not a footnote. That is a chapter. Around the same time frame, court records show that members of David's own family were also subpoenaed to appear. The specific purpose of those appearances has not been publicly disclosed, and I am not about to pretend I know what they said in that room. What I can tell you is what legal analysts have suggested, that family testimony in cases like this typically fills in the human relationship geography. The context. The who knew who lived where, who was in touch with whom kind of information that prosecutors use to stitch a timeline together. No family member has been charged with anything in connection with this case. Whether any of that family testimony ultimately ends up in front of the judge at the preliminary hearing, well, that remains to be seen. But you can bank on it that the defense is going to want every word of that testimony sitting in their folder before they walk into open court. And listen, while all of that was unfolding, another situation was quietly brewing on a completely different floor of this story, one that a lot of people have not fully processed yet. According to NBC News reporting, more than a dozen employees at the Los Angeles County Medical Examiner's office were placed under an internal review after officials began raising concerns that confidential investigative files may have been accessed without proper authorization. The reporting suggested, not confirmed, that some of that internal inquiry may have touched material related to this very case. And that immediately raised a question that a lot of people online started asking out loud: could a mess inside the medical examiner's office actually blow back on the criminal case itself? Could it derail this whole thing? Because if it can, sweetie, that changes the math on everything we have talked about so far. The whisper going around legal circles is, probably not. And here's the reason. An internal administrative review inside a government agency is a completely different animal from the evidentiary record that gets presented in court. The physical evidence in this case, the forensic material recovered from the garage, the material recovered from the Tesla, the digital communications, the purchase records, the extensive chain of custody documentation, all of that was gathered through formally authorized channels. Unless a court specifically finds that the actual handling of a specific piece of evidence was compromised in a way that affects whether it can be admitted, the administrative situation at the examiner's office is not expected to move the needle on the criminal trajectory. That said, and this is important, Blair Berk is exactly the kind of defense attorney who will look at a story like that and start hunting for angles. She is going to poke it. She is going to test it. Because that is what a good defense lawyer does. Every institutional question, every procedural crack, every documented irregularity becomes a potential lever. She will not walk past it. Nobody in her position would. Now let me pull the camera back and put you in front of the real question everybody has been chewing on. What happens when the preliminary hearing actually cranks all the way open in front of a judge, in front of cameras, in front of witnesses? Because here's the thing. For months, this case has lived almost entirely in the dark. Sealed motions. Closed proceedings. Filings under wraps. The preliminary hearing is the first sustained window where the public gets to see prosecutors actually stand up, walk to the podium, and start laying pieces of their case out on the table. That shift, from shadow to spotlight, is enormous in a story that has been almost completely invisible until now. And honestly, it is going to be uncomfortable for everyone involved, because a lot of what has been happening quietly is about to be happening loudly. And what's going to happen in that room? Prosecutors are going to try to establish something called probable cause. Now, that standard, it is meaningfully lower than the beyond a reasonable doubt bar that they would eventually need to hit at a full trial. But it is not free. They still have to bring real witnesses. Real testimony. Real physical exhibits. They still have to walk the judge through enough of the story to justify letting the case continue. They are not required to show everything they have, in fact they almost never do, because a preliminary hearing is not a full case reveal, it is a preview reel. But whatever they choose to lead with, the witnesses they pick, the categories of evidence they open the door on, the sequence they arrange it in, is going to tell us where prosecutors think their case is strongest. And that is a signal we have never had before. That is a tell. And Blair Berk is going to read it. On the other side of the aisle, Blair Berk and her team get to cross-examine every single witness the prosecution calls. Every one. She gets to challenge the way the evidence was collected. She gets to question the chain of custody. She gets to test the authentication methodology behind any digital records that come in. And now, with the grand jury transcript sitting in her folder, she gets to line up what a witness said months ago in a locked room against what that same witness is saying today in an open courtroom. If those two versions do not match, sweetie, she is going to make sure the judge notices. That is the whole game. That is the entire craft of criminal defense at the level she operates on. You have to remember the scale of what prosecutors reportedly gathered here. We are talking about something in the neighborhood of 40 terabytes of digital evidence. More than 54 search warrants. A court-authorized wiretap. Forensic recovery from the Hollywood Hills garage. Forensic recovery from the Tesla itself. Documented purchase history under an alleged false name, Victoria Mendez. iCloud communications pulled off David's devices. That is not a small file cabinet. That is a mountain of investigative material. And only a slice of it is ever going to see daylight during the preliminary hearing, because the rest of it is being held in reserve for the trial phase. What the world sees at this hearing is a preview, not the full film. Not the credits. Just enough to justify pushing forward. Keep that framing in your head as the coverage rolls out over the next few weeks, because the temptation is going to be to treat every day of the hearing like a total case reveal, and that is simply not what a preliminary hearing is. Set the expectation now, or the coverage is going to confuse you later. Now, don't sleep on the fact that the family of Celeste Rivas Hernandez has been waiting on formal public accountability in this case since September of 2025. That is a real family. A real young girl. A real, gut-level loss that a real family has been carrying while the entire legal process has been unfolding in slow motion behind closed doors. Whatever your take is on the accused, whatever your reading is on the evidence, the human center of this story is a family that has been waiting for a public reckoning for the better part of a year. And the preliminary hearing is the beginning, not the end, of that reckoning. That is worth naming out loud. That is worth holding in your head as we track the days ahead. So look, one more piece of this that I really want you to understand before we close the loop tonight. The judge's decision to allow limited release of the grand jury transcripts is not, I repeat, not, some prosecution defeat or defense triumph. It is a procedural development that actually serves the fairness of the whole process. Grand jury secrecy exists for reasons that protect defendants just as much as they protect prosecutors. It protects innocent people from being publicly accused based on untested claims. It protects witnesses from intimidation. It prevents interference before charges are formally filed. But once those protective purposes have been served, once charges are on the books, once the adversarial process has begun, there are strong constitutional reasons why a defendant should be able to see what was sworn to about him behind closed doors. The judge's decision reflects that principle. It is the system doing what the system is supposed to do. And frankly, whether you are rooting for the prosecution or the defense, that is a development worth taking seriously. The whisper going around legal analyst circles tonight is that Blair Berk's cross-examination in the sessions we have already seen has been laser-focused. Chain of custody. Authentication of digital records. The technical foundation of every forensic conclusion. Nothing scattershot. Nothing performative. Everything precise. Now that she has the grand jury transcripts in her folder, those lines of challenge are about to sharpen even further, because she can start walking witnesses back into their own prior statements. Sweetie, that is going to be must-watch courtroom television. If you thought the coverage was tense before, get comfortable, because we are entering the phase of this story where every question, every pause, every hesitation is going to matter. Every syllable that comes out of a witness's mouth is going to get measured against the record. That is a level of pressure most witnesses have never lived through in their lives. There is also a bigger picture piece here that I do not want you to lose track of. Cases of this magnitude do not just move on evidence, they move on narrative. And the narrative right now is in flux. For months, the only version of the story available to the public was the version prosecutors were letting drip out. Now, with transcripts in the defense folder, Blair Berk has the raw material she needs to start building a counter-narrative in real time. Not spin. Not talking points. A documented, sworn testimony-based counter-narrative that she can deploy in the courtroom the moment a witness contradicts themselves. That is a completely different game than the one the public has been watching so far. And it is going to reshape how this case reads on every platform from tomorrow morning forward. Where does this all leave David? He has entered a plea of not guilty to every charge. He is presumed innocent until the evidence establishes otherwise. Whatever the ultimate outcome, that outcome will be shaped by the evidence, by the arguments of skilled attorneys on both sides, and by the rulings of the court. That is the process. That is the framework. And that framework is finally moving from the shadow phase into the daylight phase in a case that has been almost completely invisible to the public for the better part of a year. So whether you have been following this from day one or you just tuned in tonight, know that you are stepping into this story at the exact moment the temperature is about to rise. Now, I want to hear from you, because I know y'all have opinions on this one and I know they run hot. Do you think this transcript release is a game changer for Blair Berk and David's defense, the kind of move that legitimately reshapes the trajectory of the case? Or do you think the prosecution has enough forensic firepower stacked up behind them that even a full transcript in the defense folder is not going to move the needle at the preliminary hearing? Tell me your take down in the comments, the exact scenario you see playing out, because I read every single one, and I want to know what your gut is saying tonight. And listen, if there is a specific piece of this story you want me to dig into next, the forensic timeline, the Neo situation, the medical examiner's office review, the wiretap chain of custody question, drop the topic below and I will cover it in the next breakdown. Because the whisper going around is that we are nowhere near done. Every step forward in this case is going to be covered right here, as fully and as accurately as the public record allows. So make sure you are subscribed, make sure you have notifications on, and I will see you in the very next one.